It's not rich white guys driving taxis, right? Instead, it's immigrants, it's the poor who need protection, constitutional protection, for their economic freedom the most. My name is Tim Sandefur. I'm a principal attorney at the Pacific Legal Foundation. The book starts out with a history of the right to economic freedom, which since at least the 17th century was considered a fundamental part of the common law rights that are enjoyed by every English subject before the Revolution and every American citizen since then. It's one of the fundamental rights that the authors of the 14th Amendment hoped to protect at the end of the Civil War for all Americans, because of course before the Civil War a good third or half of all Americans were denied economic opportunity. And so the 14th Amendment, when it was enacted, protects our privileges or immunities of citizenship. And when you look into the debates of what that term means, they say over and over again that it was intended to protect economic liberty. And that right was protected up until about the 1930s. And it was in the 1930s that courts began to shy away from protecting this right and expanding government's authority to control our economic choices. Well, I was working on a case not long ago here in Portland, Oregon, where my client was a college student named Adam Sweet, and he decided to help put himself through college by starting a moving company. And in Oregon, there's a law that says if you want to run a moving company, you first have to get permission from all of the existing moving companies. And ridiculous as this law is, in fact, it is very common. Most major metropolitan areas in the country have laws like this to regulate the taxi industry. If you want to open a taxi company, you first basically have to get permission from all the existing taxis. So these cartel laws have been on the books for many years. So Adam contacted us and we filed our lawsuit and we argued this law doesn't protect the consumer. It has no connection to helping consumers or protecting public safety. It just exists to protect established companies against fair competition from entrepreneurs like Adam Sweet. And fortunately, while that case was pending, the state of Oregon decided to repeal that law. And so Adam was able to get his license and run his business. But like I said, these laws exist on the books of many states. And just about 3 weeks ago, we filed a new lawsuit in Missouri challenging an almost identical law that says if you want to run a moving business, you first have to get permission. My client in that case actually has a federal license that allows him to move from one state to another, and he has a state license that allows him to move within the city of St. Louis. But he's not allowed to move people within Missouri outside of St. Louis unless he gets Allied Van Line's permission or Atlas or whatever these companies are. And unsurprisingly, they're not really eager to give permission to allow competition. These laws are based on absurd, outdated, New Deal era economic theories. And more importantly, they violate the fundamental constitutional right to earn a living without unreasonable government interference. Right now, the legal establishment ridicules the idea of economic liberty as a constitutional right. They see this as something that it simply isn't worth talking about. And I quote some of the very extreme language that law professors use when deriding the idea that economic liberty is a constitutional freedom. So one thing I'd really like to do is help change the climate of opinion and restore at least the recognition that for 150 years before America was even founded, the right to earn a living without unreasonable interference was being protected by English courts in England. There was a case in 1600 or so where the Queen of England granted a monopoly prohibiting people from making and selling playing cards, except for one company. So another guy made and sold playing cards, and this case went up to England's version of the Supreme Court, and the court said that this monopoly was illegal under the Magna Carta. Well, that was 175 years before the Declaration of Independence. And yet, if you were to go into most law schools today, law professors will tell you that the idea that economic freedom is a constitutional right, or is a right of all Americans, is ridiculous. That's the number one thing I'd like to change, is the climate of opinion in that regard. And secondly, I'd like to really draw attention to the fact that here is a fundamental liberty right that it's not something that protects wealthy established companies. I mean, it's not big rich corporations like IBM out there that are suffering from these things. It's entrepreneurs, it's little guys, it's the small scale inner city entrepreneur who decides to paint the word taxi on the side of his car and try and run a taxi company. It's these guys who suffer the most from these intrusive occupational licensing laws. In fact, the people who benefit from economic regulation are the wealthy corporations. So the second thing I'd really like to do is to appeal to liberals, appeal to the left, and say, look, if you really care about the poor, about the downtrodden, about people who are trying to make a better life for themselves, you need to take economic liberty seriously. Because, you know, it's not rich white guys driving taxis, right? Instead, it's immigrants, it's the poor who need protection, constitutional protection, for their economic freedom the most. The government infringes on our economic freedom in a wide variety of ways, and that's what the second half of the book tries to cover. So I start out with a history of economic freedom and the law, and then cover some contemporary controversies. So in the area of tort law, for example, government allows people to sue businesses for the most frivolous or worse, for really vague things. There is, for example, a tort called public nuisance. Nobody, no lawyer or judge in America can tell you what the words public nuisance actually means. It's so vague that it has been applied to virtually anything. And unfortunately, it's exploited by enterprising attorneys who want to sue businesses and get lots of money from them. Even for perfectly legal conduct. For example, Attorney General Jerry Brown in California, not long ago, was litigating a case against the General Motors Corporation, arguing that it was a public nuisance for them to make and sell automobiles, even though it's perfectly legal to make and sell automobiles, on the theory that it contributed to global warming. We have lawsuits against oil companies for making and producing oil. We have lawsuits against paint companies for selling lead paint back when it was legal to sell lead paint. They're suing them now on the theory that this is a public nuisance. So this doctrine is so vague it can be applied to anything. Well, if people can sue each other over these incredibly vague things, that's going to deter businesses from investing money, hiring people, researching and developing new products, lowering their prices and things, because what they're going to do instead is hoard their money as insurance against future lawsuits. So this is an example of how even tort law is abused to deprive people of economic opportunity, which hurts consumers and denies the freedom of entrepreneurs in many cases to go into business for themselves. They're afraid that if they start a business they might get sued, and who knows what might happen. A lot of the problem is not so much that we're killing the golden goose, but a lot of the legal community, a lot of the situation in the law today is that we tend to take actions that prevent the golden goose from ever being born. We don't know the costs that these laws inflict on us because so much economic opportunity is just stifled. No business is started. No new invention appears on the market. And of course we never notice that. So it's impossible to assess the true costs of our economic policy sometimes.